All right, everyone, welcome to today's HOA Forum. My name is David Donnelly, and thank you very much for joining us today for board responsibilities after HB22 1137. We still have a couple people coming into the course today, but at the same time, I think we can go ahead and get started. At the onset here, the chat is open for everyone to submit questions by way of, and I have also already put a couple links in the chat for everyone to take a look at to address some preemptive questions. First and foremost, of course, the website for the HOA Information and Resource Center, and then also an email address where email inquiries can be delivered. And then finally, and perhaps most importantly, the recording of this presentation, as well as the slides of this presentation, will be available early next week once we do a little bit of editing and cleaning up of the recording through the third link in the chat there, which is dre.colorado.gov/recent/dash HOA-forums. So that information is important for you and any of your colleagues or friends or neighbors that would like to participate and listen in on this recording, or at least at a bare minimum review our slides after the fact. So today we're here to talk about House Bill 22-1137. The purpose of this presentation specifically is to discuss this recently passed bill, and this bill, it addresses a lot of different things, including collecting assessments, providing notices of violations to communities, and as well as several other issues that we'll talk about today. The bill became effective on August 10th of 2022, and that means that this bill affects each and every one of your communities now, today, and into the future. So I want you to be prepared for that as we work through these, thinking about potential questions and issues and that may be particular and relevant to each of your respective communities. As I said before, my name is David Donnelly, and I'm the manager of the Education, Communications, and Policy Program with the Colorado Division of Real Estate. The Colorado Division of Real Estate is, of course, a part of the Department of Regulatory Agencies, many of which you will know that agency by its nickname, DORA, D-O-R-A. With me today, I'm very pleased to introduce you all to Nick Altman. Nick Altman is the new HOA Information Officer with the Division of Real Estate. So with that being said, Nick, if you'd like to jump on real quickly and say hello to everybody, that would be wonderful.
Oh, hi, David. Looks like I'm having some video issues, but yeah, thanks for having me, and excited to be here.
Excellent. And along with Nick, we also have Amanda Lopez, the HOA Information Support Specialist.
Oh, cool. Okay. Good morning. Good afternoon. My goodness. Good afternoon. Thank you, everybody, for joining. And we all look forward to doing this. So thank you for all joining with us.
Excellent. Well, thank you, Nick and Amanda. I'm very excited about the changes we've got here in the office. Nick and Amanda are really an excellent team, and I'm looking forward to it. And I certainly will continue to be a part of their team as well as we hand these responsibilities over to Nick as the new information officer for the HOA Information and Resource Center. But it's a very exciting time, and so let's get going. As many of you know, that any of you that have attended our courses in the past, you've seen a similar slide to this one. The information that we're providing here today is for educational purposes only, and it is not meant to provide, nor should it be construed as legal advice. Any specific legal questions that you have should be directed to a qualified licensed attorney here in the state of Colorado. The HOA Information Resource Center does lots of things. we register HOAs, we complete an annual report to the legislature, we provide website resources available for the public, and we conduct these types of educational forums. All of this type of work, it surrounds primarily the Colorado Common Interest Ownership Act. Some people will refer to that as CCIOA, and others of you might know it by its nickname, which is Kiowa, pronounced or like the Native American tribe or like the city here in Colorado. So I always like to point that out, especially for newcomers to our forums, that the Colorado Common Interest Ownership Act, CCIOA, also known as Kiowa. I tell many callers my own story, which was that the first time that I stepped onto the board of an association, I had other board members referring to Kiowa this and Kiowa that, and I didn't even know what Kiowa was at that time. And because I was looking for something that was spelled Kiowa, like the city, all the while it was just this acronym for CCIOA. So I had egg on my face, but nevertheless, I want none of you to experience that same experience that I had. So, so there you have it. With what the HOA Information Center does not do. We are not a regulatory program, and we do not provide mediation or arbitration. As any inquirer has known, we also are not able to provide legal advice, and as such, we also cannot and do not act as an advocate. There are many times where we speak to both sides of disputes. Our responsibility, our job here in the office, is to help callers, inquirers, whether you're an owner or a board member or a community association management company or a first-time homeowner or even a licensed attorney in the state of Colorado, help them understand what their respective rights and responsibilities are pursuant to the Colorado Common Interest Ownership Act. So it is very common that we speak to both sides of these situations. That is why I point out how we are not an advocate. We are an impartial organization that wants to assist callers better understand what their responsibilities are. So with that being said, I've already made a little bit of a reference to the fact that there are homeowners on this call. There are definitely board members, and this presentation is also very appropriate for community association managers, and so that's who this presentation is primarily designed for. During the year 2022, the Colorado General Assembly, which constitutes two primary branches, the House of Representatives and the State Senate, they convened on January 12th of 2022 and adjourned on May 11th of 2022. During that period of time, there were several bills that passed through the legislature. I mean, there were hundreds of bills that passed overall. There were only 5 bills that ultimately affect common interest communities specifically. Those can be identified here: HB22-1040 and HB22-1137, what we're here today for. Also 1139 and 1314. And Senate bill, that's SB 22-059. Each of these bills deals with very different things, as you can even tell from just the names of the of each of the bills that are identified here. There are summaries of each of these bills available on our website for anyone to review. All of these bills are complex in their own rights and very important in their own right, but what we want to talk about today is HB 22-1137. So throughout this presentation, you may hear me refer to the bill or HB 22-1137. Kind of going forward here, everything that we'll be referring to is going to be derived from this specific bill that became an act or a law through the passage through the House, the Senate, and then being executed by the governor. So The bill's common name is the Homeowners Association Board Accountability and Transparency Act. This bill, as I mentioned earlier, is very complex, and it is a very comprehensive bill. It covers a lot of information, and no doubt that's why there are as many attendees as there are today, because a lot of people out there want to better understand what this bill says, what it does, where it gets its fingers onto. Some of those are those things specifically are the HOA collection process, but also providing notices of violations, a drastic decrease in what interest rates that are permissible to be charged, as well as an expansion of access to the judicial system, to our court system here in the state of Colorado. And we'll be talking about each one of those sections. So before we get too much further into this, I want to talk about a common misconception that I've heard a lot from callers into the HOA Information and Resource Center, which is they think that, hey, some of you might be familiar with a series of media presses and press releases and the like about some foreclosures that took place here in the Denver market primarily. This bill is not a direct reaction to that, although that's what a lot of people believe it to be. The reality is that this bill has been worked on for quite some time, well before the media started to pick up on some of these news stories. Here are just a couple clips from some of those titles. Various news organizations, both print and video, news media across the board, have picked up on some of these stories, and certainly I would encourage you to read some of these articles. They're well written, very well detailed, researched, and they shed a lot of light on some very relevant issues that are going on today. However, again, I want to reiterate that the bill we're speaking about is not a reaction to these to these media stories. So HB 2237 had 4 primary sponsors in the offices, and that is Representative Nikita Ricks, Representative Mary Bradfield, Senator Julie Gonzalez, and Senator James Coleman as the primary bill sponsors for HB 1137. There were other sponsors as well, but these are the names first and foremost that might be helpful for each of you. If you have additional questions or concerns, I certainly encourage you, of course, to reach out to your own representatives and your own state senators. However, and you can let them know that that you know about this bill, you know who those sponsors were, things of that sort. But one place to start here with this is some new vocabulary, new concepts that were created by this bill. And there are 2 primary ones that I'm going to talk about with you. The first is a preferred language. Under this new bill, a unit owner may notify an association if the unit owner prefers that correspondence or notices from the association be made in a language other than English. If a preferred language is identified by a unit owner, notices of a delinquency or notices of a violation must be delivered to that unit owner in English and the preferred language. The bill is silent as to who's responsible for paying for these translation services. I think that there's a strong argument to be made that I cannot just write up a letter, a notice saying you're behind on your assessments, and put that into Google Translate or something to that extent. This is a legal document, a legal notice that you are sending out as a board member, and Google Translate does not necessarily take those contextual issues into play. So a professional translation service may be appropriate. It is certainly something that you as board members should consider. The bill, although the bill does not discuss who is responsible for paying for that translation service, i.e. can that fee be passed on to the homeowner, to the unit owner or not, is subject to some debate, and very well could be determined either by subsequent legislation or by a court making determinations in that respect. But this preferred language is a very important concept. Colorado has many non-native English speakers, and that speak a variety of other languages. This bill expands our ability to access and communicate effectively with our homeowners in each of these situations. The next vocabulary that I want you to be familiar with as we talk about it, because you'll see it as we chat more, is the designated contact. A unit owner is permitted to identify another person to serve as the designated contact for the unit owner. That communication, any communication that would come from the association that would go to the owner should also go to a designated contact if the unit owner identifies one. A board would be responsible for designating or creating or establishing, I suppose is the better word, a methodology by which they can collect this information from their respective homeowners. A simple suggestion would be when someone moves into the community, collect that information on their contact sheet. Do you have an additional contact that you want to have all board communications with you not all communications, I stand corrected, communications with respects to either your delinquencies and assessments or a notice of violation. But this is important. It could be your sibling, it could be your best friend, it could be your lawyer. There is no specific limitation on who your designated contact can or should be, but it merely grants the unit owner the authority to establish that. So association board members, I encourage you to consider a manner by which you can collect this information, how you can identify that, because if you don't have a formal process or procedure in place, and I just shoot you an email saying I'd like Amanda Lopez to be my designated contact, if there's not another process, a formal process in place, that's good enough. And if you then don't follow that, if you do not comply with the law, you could be facing some complications down the road. So creating that formal process is going to be a help to you board members going forward, as well as, of course, having a clear directive for each of you as homeowners to understand this is what I need to do in order to create or to establish who my designated contact is. So with those two new terminology, new phrases that we're going to use, I want to get more into some of the meat and bones of the bill. Prior to 1137, there was no express requirement that boards kept a record of how or when or where or anything of that sort, a type of communications that I have with my homeowners. But 1137 expressly establishes a requirement that boards create a record-keeping process, and this is with respects to any attempts to contact the unit owner for a delinquency or for a notice of violation. These writings clearly should be made in writing. With that being said, is an Excel spreadsheet okay? Probably. Is written on a bar napkin acceptable? It probably is as well. However, you are running a business, and that's an important reminder for each of you to consider. Creating a formal process that is reproducible for every association unit owner, that's going to be better. The statute expressly states that the records should at a minimum include the date, the time, and the method of contact. December 16th at 1:15 by email would be fine. That complies with the statutory requirement. If there is additional information that your association deems appropriate or necessary to collect, there's no limitation on collecting other information, but at a bare minimum, date, time, and method of contact. So why are we communicating with the association, as the association, why are we communicating with our homeowners? The first type of communication that we're going to be talking about as a result of 1137 here is past due notices or a delinquency notice. These notices must now be sent by certified mail with return receipt requested. They also must physically be posted on the unit on the unit owner's property. If it's a condo, maybe you slip it into under the front door, or you tape it to the front door. If it's a home with a mailbox you have access to, maybe you can put something in the mailbox. What if it's a vacant land? That question's come up a lot. If it's vacant land, there's no door for me to tape the thing to. There's no mailbox for me to put it in. In that type of situation, maybe it would be appropriate to have a stake and that you hammer into the property right by the driveway, or the entrance to the property, whatever the case might be. But that physical posting is imperative. It must be followed. And with that being said, I always want to encourage safety in these situations. If someone's coming up to me and saying I owe them $10,000, I'm not going to be too happy. But while I wouldn't react negatively, it's possible that you might, or that other homeowners might, and therefore safety for your board members is really imperative. I want to stress that for all of you to consider in doing this in a careful way, so that you don't endanger yourselves in any situations. Someone recently sent me an article from the state of Florida where a homeowner harmed a board member and their spouse as a result of some of a dispute. And so yeah, Heather's asking the right question. What if someone's hostile? Who's supposed to go up to their property and post the notice on their door? Traditionally, in most situations, I think that this bill considered it being a board member. But if there is hostility, if there is the fear of lack of safety, you could consider in some cases it's possible that law enforcement would assist you. If not law enforcement, a process server who tends to be a big and burly person, usually carrying a badge that says that they're a process server, might be an option as well. So that's an excellent question, Heather. It's very important. But you remember, there's also cover of night. You can do this when they're not home, things of that sort. You don't need to talk to this person. You just need to physically post on the property. Tyrone's asking about cost there. There is no, much like what I mentioned a moment ago, there isn't a cost provision that would prohibit a board from passing that cost on, but I would encourage board members to ensure that it is a reasonable cost, that it is actually tied to something. I don't get to say posting of notice on property $200, because that's not what it costs. That's not what a process server costs. That's not what it costs for you to do it. And it has to be a real cost. It cannot be a, oh, well, we assume that there's going to be a cost here, so but then I'm just going to go do it myself and still charge the fee. It has to be a reasonable cost. It has to be an actual cost. So that's a good question. Bill's asking whether it has to be certified and first-class mail. If you get to number 3 here, the third option can be sent by first-class mail text message, which if you think about sending a notice of delinquency by text, that doesn't really make a lot of sense because you can't really send that much information in a text. But if you have the ability, then that's okay. And thirdly, an email would be perfectly acceptable as the third method. All of these 1, 2, and 3 on this slide are required. So by mail, which is certified with return receipt requested, that's number 1. Number 2, physical posting on the property. And number 3, either first class mail, text, or email. Keep those in mind. Can't skip any of them. These notices.
David, we do have a question. Sorry, I don't mean to interrupt. We do have a question in the chat. I know we're in the Q&A. I apologize. And I wanted to see maybe we can get those answered. So we have a question in there that asking if all 3 methods need to be completed, or is it just one as far as the notices?
All 3.
Okay.
Absolutely. Good question.
Right. And then one more. So is the delinquency notice, is that supposed to be posted on the door of a unit that is rented, and she's saying the owner may not be happy with that? So I know we went over as far as how to send that the notices out, but I'm not sure if that answers that question for her.
Even if the owner doesn't live there, even if it's a vacation property, even if you know for a fact that the owner is there for 3 days every single year, the statute states that it has to be posted on the unit, at the unit. I mean, in the case of a vacant property, perfect example, nobody's living there. It's vacant. There's no house, there's no tent, there's no trailer. It is vacant. It is vacant land. You have a affirmative responsibility to post on the property. So it doesn't matter if it's a renter or a sub-rent leaser, it does not matter. The statute states it as such. The mailing and the emailing and text messaging, that's a little bit different. It doesn't say you have to mail to the property. If every owner in your community should have contact information that is up to date for your so that notices get mailed to the correct place. Because I live in Tahiti, I own a condo in downtown Denver, but I live in Tahiti. You should be mailing me my notices, all notices, a notice of a annual meeting, whatever the case may be, as well as a notice of past due delinquency or notices of violation that we'll get to shortly. Those should be mailed to the proper address there. If your owners have not provided you an updated contact information to my address in Tahiti, then you send it to the best information that you have, which is probably going to be, of course, then the unit the unit address. But it is the responsibility of your unit owners to keep you up to date as board members of where they can be contacted, email, text, and mail. And therefore, when I reach out as an owner and say, hey, please start sending all correspondences to my address in Tahiti, you should be doing that. You should not continue to send my correspondence to the unit address at that point, because I've put you on notice that that's where I expect my communications to be delivered. I see a couple of questions that are similar to if there should be any. I wished I could rent out a property in Tahiti. Sorry, Bill. I see a couple of questions asking about some delays in between the property between these postings. There's no necessarily delay. I mean, all of these things should really be going out pretty much concurrently. And then also a question about how long the posting has to take place for. The statute does not speak to that. So. So do you leave it up for a day? If it's on a stake on the corner of the property, that could be okay. Technically, but I think the general practice would be to not interfere with that. If you post it on the up on the front door, for instance, let it sit there until the unit owner gets it. otherwise you're going to lead yourself down to a world of confusion of them saying, well, you certified mailed me and with a return receipt requested, you emailed it to me too, but guess what, you didn't post it on my door. There's no evidence that you posted it on the door, so so you didn't comply with the requirements of the law. So remember, each and every one of you has a pretty useful tool in most of your pockets. That's a smartphone with a camera on it. If you take a picture of the posting, that certainly is going to be helpful down the road. So something to keep in mind there. Anything else before I jump forward there, Amanda?
We have a few questions that are coming in through the Q&A real quick. So as far as you mentioning the fees must be reasonable cost and actual cost, does that mean if the HOA doesn't incur an actual cost associated with the delinquency, can they charge a fee? So for example, if the fine for a parking infraction is $1,000, but there's no expense incurred by the HOA, would that then be reasonable or actual?
We're talking a little bit about apples and oranges, I think, in that situation. These fees that we're talking about passing through, whether it's translation perhaps or postage for certified mail with return receipt requested, or someone physically posting on the property, are all things that if the association did not incur those costs in order for it to comply with this law, you could be jeopardizing yourself. You gotta always take a moment, take a step back, and think about what a judge might think of this. I'm not a judge, but if I were a judge, and I saw someone saying that they incurred all these fees and in fact that they did not incur any of those fees, that goes to the veracity of a lot of the other things that they might be saying. And so that is you're putting your board's position in jeopardy by saying by allocating all these costs that actually aren't real costs. You would never submit an expense report to your bosses for fees that you didn't actually incur. Either. I mean, you all, some of you might get reimbursed for mileage in some of your jobs. You don't get to say, I drove 250 miles and you owe me 52 cents per mile if I didn't drive 250 miles. So really consider that in your fee structures, and I encourage all of your board members to ensure that your policies, your governance policies that are required by 38-33.3-209.5, that I encourage you to have those policies reflect that type of situation, actual cost, not a presumptive cost. So certainly something to consider there. What about, let's do one more before we move on.
Okay. So does a phone call reminding of past due assessments count as a notice of delinquency?
I do not believe that that there is any provision for a telephone call being adequate pursuant to the new requirements that are found in HB22-1137. And I think there's a couple of reasons for that. Even if it was permissible, I would encourage you all to consider the fact that if you and I get on the phone, we could be talking about the fact that you're past due and you're delinquent, but we could also be talking about the weather on that phone call. There's no way to tell what we're talking about on a phone call. If I send you an email, if I send you a letter, if I physically post a copy of that letter on your property, it's unequivocal, it's undeniable that we in fact were corresponding about a specific thing, which was in this case the delinquency that you owe, advising you of your rights, advising you of your opportunity for a payment plan. We'll get to those two things in just a sec. So a telephone call, while it might be a good way to communicate with some people, it does not necessarily satisfy this requirement. There's a lot of people out there in the world that just say, you know, just pick up the phone and talk to me. Okay, great. I will do that if that's the way you'd like me to talk, but that does not forgive or preclude my requirement that I have to fulfill my obligations as a board member and do 1, 2, and 3 on this list. Make sense? Let's talk about the right to a payment plan. In addition to the requirement that your notice of delinquency states that you have, as a unit owner, the right to a hearing with the board, the notice must also include an advisement to the unit owner of their right to a payment plan, to a repayment plan. In olden times, before August, we had a law in the state of Colorado that allowed for up to 6-month-long duration payment plans. That means, let's say if I owed $600 to you, that I could pay you $100 per month. That law is gone. The new law is, and the new standard is 18 months. That means a lot has, that is a big difference for a lot of your communities. It is also now expressed that you as unit owners, you as board members, forgive me there, as board members are required to advise the unit owner of the right to this payment plan. These payment plans are allowed to be devised by the unit owner. If I owe you $600, maybe that's a bad example because of the math. Let's say I owe you $4,000. I am allowed to say, well, I want to pay you $50 this month and $75 next month, and then $50 in month 3. I can devise a plan of my liking, provided that it satisfies the bottom line of this slide, that every payment, monthly payment, has to be at least $25. So $25 per month. If I owe you $4,000, I think that the way that the statute is written says that I can pay you 17 months, I can pay you $25, and then in the 18th month, I can pay you a balloon payment of the remaining balance. That is something that as a unit owner, I am allowed to devise. Now, you can certainly encourage that unit owner to work with you and be more, and come with it up to a better number, a more mutually acceptable number, but the statute provides that that the unit owner gets to decide those terms. So, but you must provide them an 18-month period, and you always have the right to say at least $25 a month. So if I owe you $400, $25 a month is not 18 times 25 is more than 400, if I'm doing my math correctly. Therefore, I have to at least pay you $25 per month. That is going to be 16 months at $25 a month to pay my $400 fine. If it was 500, then we would be just over 25 a month on if it was a standard number. So keeping those numbers in mind, okay? 25 is the bare minimum. Also, once a payment plan has been put into effect, or if the unit owner has not chosen to elect for a payment plan, the board has a new responsibility. It has to, on a monthly basis, provide unit owners with that have a delinquency with an itemized list of all assessments, fines, fees, and charges. That doesn't mean I get to say, David owes the association $400, period. No, I probably owe the association $250 in principal and $50 in late fees and such in fines and such in other charges. It has to be an itemized bill, an itemized invoice, and it also must be provided to the unit owner monthly and for free. How are your payments going to be applied during the during a repayment plan, or at any time when a delinquent homeowner is making payments? The law now says, and this is very different than what the law used to say. Payments are now first applied to the assessments, or what some of you would refer to as the principal. And so in that example I said a second ago, $250 of principal and then $50 in fines, et cetera, et cetera. The first $250 that I pay goes to principal. And then anything I pay over that will be applied to fines and fees and other charges. This addresses a couple of things for both parties. One, it gets the association the money that it says that it's owed. The principal is what you should be relying on. The principal, the assessments, is what you are relying on for your budgetary purposes to pay your expenses as an association. It also allows the homeowner to reduce the principal and therefore reduce the fact that they're incurring other fees and charges and most notably interest. In the before times, before 1137 existed, we heard a lot of concerns about people who had a principal that they could never reduce because all of their money every month that they paid, and they paid religiously every month, it just went to servicing the fees and fines and interest on the debt. Therefore, they never got to a solution. It's sort of like a credit card. You incur a lot of interest on a credit card if you carry a balance, but in that case, your money's going to the interest rate first. And then anything after you've satisfied the interest rate gets to pay the principal down. 1137 flips that around so that your payments are first applied to assessments and then to those other fees. The association is also now limited on when it can and how it can pursue a legal action. The association can only pursue a legal action if A, the owner does not enter into a repayment plan and chooses not to pay the amount back, or B, if the unit owner does have a payment plan, but the unit owner then fails to pay at least 3 monthly payments, 3 of those monthly installments. That means in my 18-month period, I was short on cash in month 2 and month 3 and month 5. Once I've not made those payments, that is a trigger that would allow the association to begin to pursue a legal action. But if I pay all of my 18 months on time, then the association is prohibited from pursuing a legal action. And the association also must have a validly adopted written policy governing the imposition of fines. And furthermore, what good is a policy that you have as an association if you don't follow the policy? So of course, you must follow that written policy. And when I say policy here, these are the policies that I'm talking about that are required under section 38-33.3-209.5 of Kiowa. So that subsection 209.5 is what we're talking about there. When can a board refer a unit member to an attorney or to a collection agency? In the before times, associations could, or their community association management company for that matter, could retain counsel at any time. I owe you 55 cents. It could, guess what? It could have gone to the attorney. Now that's not smart for an association to do, but in theory, it was legally acceptable. I as a board member could refer a case to a lawyer at the ready, but with HB22, that has been amended. Now boards must take specific action and notably in an executive session before the unit owner is sent to collections. And when I say collections, I mean a collection agency or a collections attorney. It doesn't matter. That's a catch-all term. Okay, I just want to be clear about that. The board is expressly required to vote in a closed hearing, which is read to be an executive session, and in that executive session, they are required to refer the unit owner's account to a attorney or a collection agency. The unit owner, and this is a unique thing, this is unlike any other type of executive action or executive session action that can be taken by a board. The unit owner, the affected unit owner only, is allowed to request the results of that vote. So, so Nick, Amanda, and I are the board, and we go into executive session to vote Unit 101 to go to collections. The owner of Unit 101 has the right to know how we voted and that we voted on that topic. This slide, it's a little bit off topic, only in that it's beyond the scope of this specific presentation, other than subsection E here. The highlighted, bolded, and italicized section here was expressly amended by HB 1137, and it was done so in order to expand and to allow for these disciplinary action hearings to be held in executive session, and that the unit owner who is subject to the disciplinary hearing or referral of delinquency may request and receive the results of any vote taken at the relevant meeting. The emphasis added is my terminology, just to call your attention to it. That's why it's highlighted, that's why it's bolded, and it's why it's italicized, because this is new language. But I wanted to include the other sections of this part of Kiowa from section 308, because a lot of people call us and say, when can I go into executive session? And there are limited, and I mean, as you can see, A through F, these are the only reasons that are acceptable, the only reasons that are allowed by law for you board members to go into executive session. You can't go into executive session for other reasons. So keep that in mind. But again, subsection E is the relevant part here. Before we switch gears and begin to speak about notices of violation, anything you would like to ask? Any questions sticking out there, Amanda?
Well, we have quite a few, actually. A lot of questions came up on that last one, a lot. So I'm gonna go from the bottom up. So executive session vote. Does a homeowner get individual votes or the number of votes agreeing with the passing to attorney collections?
The homeowner does not get to vote. It is a board vote. The board goes into an executive session, and the board votes on whether or not to refer to a collection agency or an attorney. The unit owner does not have a vote in that situation.
Okay. So is this part of the discussion? Is this part of the discussion just about fines, or is it about regular assessments that are delinquent, is what Kathleen wants to know.
The section of our presentation that we've kind of rounded up here pertains to any time there is a delinquency on a unit owner's account. So that could be due to regular assessments, that could be due to a special assessment, or that could also include interest, fines, fees, penalties of the sort. With the caveat, though, that those fines, fees, and penalties, and it's actually a perfect question to, because the slide that we're looking at right now states it, no foreclosure is allowed on balances that only are comprised of fines, interest, late fees, or attorney's fees. That means that what that means in another way is that a homeowners association cannot foreclose unless there is a principal that is owed, that unless there is a specific dollar amount due because I didn't pay it, because I didn't pay one of my regular assessments. So this whole section had to do with any type of assessment or fee or penalty, etc., that would be due and owing from the association unit owner to the association.
Perfect. David wants to know, to say at least 18 months, connotes that the repayment plan can last indefinitely longer than 18 months. How do you make sense of this is how he wants to know. So yeah, to say at least 18 months connotes that the repayment plan can last indefinitely longer than 18 months.
Good question. The association is not required to accept a repayment plan longer than 18 months. That does not preclude your board from saying, you know what, we're cool with, let's just do a clean 2 years. 24 months is fine by us. If that's acceptable to your board, then that's enforceable. But the unit owner does not have the right to a 24-month payment plan. They have the right to at least an 18-month plan, but not greater than. So if the parties agree, yes, it could be 24 months, it could be 36 months, it could be et cetera, but what the board is not allowed to do is say the only way that we will accept a repayment plan is if you pay us in 2 months or 10 months. The repayment plan can be at least 18 months. If the parties agree for it to be greater, then that's great. That means that your homeowners and your board members are working together and are being reasonable with one another given the circumstances. And I always encourage that for you all, is to be reasonable with one another. You're each other's neighbors. And so being conscious of that and working with one another is an important thing to think about.
There are quite a few questions. I'm not sure how many you want to go through before going to the next slide.
Let's do one or two, and maybe what we can do is we can try to go through some of these the questions that we're not able to hit, and see about maybe finding another method by which we can communicate some of these answers. Because the questions we've addressed so far have been very important and very good questions. So and no doubt there in the remainder here there are lots of good questions as well. So we can find a way to maybe communicate some of those.
Sure. Okay. We have some in the chat and some in the Q&A, quite a few of each. So I can stick to the Q&A or go to the chat questions. Do you have any?
Okay. No preference.
Perfect. So James wants to know if the annual dues are only $175 and the minimum payment is $25, then the 18-month payment is kind of, so how does that work?
So if the principal that is owed is $175 and I have 25, I'm allowed to pay you, or I'm required to pay you, excuse me, at least $25 per month. That's going to be 1, 2, 3, 4, 5, 6, 7 months. So because the requirement is that it must be at least $25 per month. So that's an exception to that 18-month rule. When we're talking about a relatively small balance, it doesn't get spread out over 18 months because the statute requires that the payments be at least $25 per month.
Okay, and we have a really good question though, actually. Does HB22, the new House bill, does that apply to the pre-Kiowa communities, or is that everybody in general?
Yes, it does. With the there isn't any carve out for that across the board. There is but that is an excellent question. I'm seeing one question about the interest rate, which I want to touch base, which was Mike is asking if the interest rate can change over the 18 months, and we're going to get to the interest rate because HB 22-1137 changed the permissible interest rate in all of your communities, very likely. Prior to the passage of this bill, associations were allowed to charge up to 21% in interest on past due balances, etc. That is now limited at 8%. That doesn't mean that you all must charge 8%. You could charge 2%, you could charge 4%, but you cannot charge greater than 8%. So if your association deemed it appropriate, you could say that we charge an interest rate of 8% on past due balances unless they're in a repayment plan. And if they're in a repayment plan, we'll charge 4%. You could do that. you have a lot of authority as board members to do something like that. However, your hands are tied. You may not exceed that 8% amount. Let's jump into the notices of violation for a little bit here. So we're going to talk quickly about two different primary types of violations in here. The first is health and safety violations. Your associations are permitted to make a reasonable determination on what a health and safety violation is, what threatens the quote public health and safety of your community is. So that means it must be reasonable. So I'm not able to tell you what is reasonable, but is water flowing out of a broken pipe a reasonable health and safety problem? I would probably think so, because you've got mold issues, you've got structural issues, you've got a lot of damage going on in that situation. But I'll tell you that if I painted my house a different color, that's not a public health and safety violation. So it must be reasonable, and that would be left to a court to decide if it got to that point. So I encourage you board members to think about it from that perspective. Could this pass muster with a judge? A notice of a violation, and this is any kind of violation, a parking violation, I painted my house an unauthorized color, I built a secondary dwelling in my backyard. I have a chicken coop and I'm not allowed to have a chicken coop, or I'm raising cattle in my backyard and I'm not allowed to have livestock. Whatever types of violations, these could be covenant violations or use restriction violations. But a notice comes from the board that has to be delivered to the unit owner in English and any preferred language, as well as any preferred language. That if it's a health and safety violation, it needs to provide that the unit owner has 72 hours to cure that violation, or the association may fine the unit owner. The association may inspect after the 72-hour period in order to determine whether the violation has been cured. If it has not been cured, the association may fine the unit every other day until it has been cured. If it's not been cured, the association may also take legal action against the unit owner for the violation. That includes injunctive relief. It includes other types of restraining orders that would allow you to or to require a unit owner to conduct specific performance. You have rights there as unit owners to affect those health and safety violations. But other than health and safety violations, the process is dramatically different. A written notice needs to still be provided in English and any preferred language. It needs to expressly be delivered by certified mail with return receipt requested. The notice must inform the unit owner that they have 30 days to cure the violation. My example that I always use is I painted my house bright pink. As soon as that letter comes in, I've got 30 days to fix that. If the unit owner does not cure within 30 days, the association may begin to fine the unit owner. But the unit owner, but also if the unit owner does not cure within 30 days, the association has the ability to grant that unit owner or actually the requirement to, not the ability to, I apologize, needs to give them an additional 30 days to cure the violation. So that means you've got basically 60 days, the first 30 days of which fines are not applicable, but during the second set of 30 days, they can start to incur fines. There is a cap on this. This is an important cap. Many of your association documents previously might not have be written in a manner that account for this cap. Violations of this nature are capped at $500 per occurrence. So if I'm parked illegally and I painted my house, I can be charged up to $1,000, $500 each, but I cannot be charged $1,000 or anything, or I can't be charged $505 for one singular violation. So keep that in mind as you're looking at your violation fee structures in your governing policies. But how does a unit owner cure a violation? How do they prove that they've fixed the problem? In the case of my bright pink house, I think that everybody in the neighborhood is going to know when my bright pink house is no longer painted bright pink. But that being said, that does not preclude the unit owner from still establishing that. They should the unit owner consider taking a picture and sending it to the board saying, I repainted my house a new color, everything's good now. What if it's not something as blatant as my bright pink house, but rather something internal or something that isn't as visual to or visible to the naked eye, or because it's in the backyard behind a 6-foot tall fence, whatever the case might be. A visual inspection, making an appointment with a board member to come and look at it, or again, a photograph is an excellent way to do that. Date stamps showing them that that the issue has been resolved. If the unit owner doesn't do that themselves, the association has the authority to inspect the unit as soon as practical to determine if the violation has been cured. So that means that if I don't take that picture and send it to you, that the unit owner does have the right to step in, or excuse me, that then the board members have the right to determine if the violation's been fixed. When a unit owner doesn't provide that notice of cure, the association should inspect the unit within 7 days after the expiration of the 30-day cure period. And if they did, and that's the first 30-day cure period that we're talking about. If the association determines that the violation has still not been cured, then that triggers that second 30 days. After which point, if upon another inspection, if the board determines that the issue has not been fixed, that's when legal actions can commence. So we're talking about really expanding this, stretching this out to allow a reasonable opportunity for unit owners to fix problems, which is very important. But at the same time, I certainly encourage unit owners to not try to take advantage of all of those opportunities. So if when we have the situation of a violation notice has been delivered and a cure has been established, so I've fixed my pink house, okay? The written notice that the board should provide needs to be conveyed in English and any preferred language, and it should include that a statement expressly stating that the unit owner will no longer be further fined for the violation, and also give them a status report, a statement of what the fine balance is, so that, and of course, if there is any balance that is left, so that the unit owner is clear and understands what they owe. If there is an outstanding balance, that balance should be commemorated in a monthly notification that is sent by first-class mail and by email if the association has an email address for the unit owner. And that needs to be an itemized list of all assessments, fines, and fees and charges that are paid until, and it needs to go out monthly until it has been paid in full. The itemized list should also be sent in English to any preferred language, as we stated earlier, but it should also be delivered to the unit owner and to the designated contact. So just a couple more things that I want to chat with you guys about, and then we can do some questions, because I know we're at a few minutes after 1 already, excuse me, a few minutes after 2, and so a couple things that we need to really harp on here are that the association shall not charge fees or should not charge a fee to provide a unit owner with a statement of what is owed. That means that even if I'm not in delinquency Even if I'm not in violation, I can ask for a balance from my association. This, to be clear, is not the affirmative obligation for a board to send out balances to everyone. Although that would be a pretty good practice, you'd probably, as board members, receive a whole lot less questions if you told your community members, we received your last check and you owe us $0 until you owe us more next month or next quarter or next year, whatever. Good practice, but not required. But if I, as a unit owner, call you up or email you and say, give me a statement, board members, community association managers should provide that free of charge. Foreclosures, the association may also not foreclose on an assessment debt that only consists of fines or collection fees and attorney's fees, things of that sort. We talked about that earlier. 1137 imposed a new rule, which is might be a difficult one in some circumstances to enforce, but you as board members need to know about it. No board member or an employee of a community association management company that represents the association, no employee of a law firm that represents the association, and no immediate family member of any person of these people may purchase the unit from foreclosure at the public trustees sale. That is important, and one of the reasons why is just 2 paragraphs away after I mentioned the interest rate. Interest rates need to be, cannot be greater than 8% per year now. But what I was just referencing is that if the association violates any foreclosure laws or that affect the unit owner, that unit owner has a cause of action that can seek civil damages from the association up to $25,000 plus costs and fees, including reasonable attorney's fees. The statute of limitations for that is 5 years. So think about it in the simplest of terms, board members. If you are trying to initiate a foreclosure and you don't have a valid policy in place, a valid collection policy, that could come back on this, your association up to 5 years later. Different board members, different community members at large entirely, it could come back and be a substantial cost and detriment to the community. This is a penalty. Point blank, it is a penalty that is being established by the legislature to say parties need to follow the rules. This law is not an optional law. This law needs to be followed to the letter, to the T, what have you. It's important. So I want to reiterate this interest rate issue again. Again, we were allowed before HB22, associations were allowed to charge up to 21%. That has been substantially limited and lowered down to 8%. The idea is that we want, as a state, we want to encourage the ability and create a circumstance and the ability for parties to actually pay their principals and pay their amounts. If all I'm ever doing is incurring more and more debt because of a 21% interest rate, for instance, that's not serving the purposes of this bill. That's so that's a big motivation. So one last topic, and then I promise we can answer some questions, which is access to small claims court was expanded by HB22. In small claims court, the amount in controversy, which means the amount that a party can recover from the court. I might have $10,000 worth of damages, but if I file a lawsuit in small claims court, the maximum I can get is $7,500. I might have a case that's worth $100,000. If I file in small claims court, all I can get is $7,500. That is a limitation, yes, but there are reasons for that. Plaintiffs also in small claims court are not allowed to have an attorney represent them unless the defendant has one. So if the association is going to sue a unit owner in small claims court, they don't get to have a lawyer unless the homeowner gets a lawyer, and vice versa. This access to small claims court expands both access for board members as well as access for unit owners to court. The rules of evidence are somewhat relaxed, and more importantly, the procedural processes that you find in small claims court are not as arduous, they're not as challenging to follow as they are in county court and district court in the state of Colorado. That's a big advantage to any of you that may be contemplating initiating a civil action against a homeowner or against a board, respectively. But this link, which is live, I would encourage any of you that want to get more information on small claims court to utilize this link. You can download the slides from us and access that through the Colorado State Judicial Branch website. They have lots of important information there. This next slide, I'm going to jump over really because it gets really down into the weeds of what types of cases are allowed in small claims court now, but in general, they're association disputes that relate to the governing documents. It allows to enforce a restrictive covenant. This situation, a great example would be if your community board is not enforcing the covenants, another homeowner could theoretically come to small claims court in order to enforce a restrictive covenant against another neighbor. Replevin is a legal term of art that talks about how you can recover property that has been improperly seized from you, provided that the property that in question is limited to $7,500. You can now access the small claims court for a action in Replevin. And then finally, to allow specific performance on a contract. Specific performance is a fancy term for basically to say to require a party to do something specific. Going back to my example from the second bullet point here, if a homeowner wanted to require a board to perform something specifically to enforce their association's covenants, that a homeowner could take the association to court in order to force them to do so. That is now allowed in small claims court. So this is an important one of my final slides for you, which is every year the HOA Information and Resource Center provides legislative summaries to you all that are available to the public. Here is the link. You can also find this link through our office's main HOA Information and Resource website. But this bill has a detailed summary, as well as the other bills that we introduced at the onset here. Every one of those bills has a summary, and because every one of those bills affects different aspects of life in an HOA. So I would encourage you all, if you have not reviewed those summaries in the past, to please do so. They're very helpful, and I feel very valuable. An excellent place to start answering your questions. With every association meeting here, I always like to end with some tips. Board members, review your governance policies and that are required by section 209.5 and ensure that they comply with the new law. Board members and CAMs, I highly encourage you to be as transparent with your communities as possible. Disclose your governance policies. Let them know if you've changed them. Let them know if you've updated them. Tell them once, tell them twice, and tell them 3 times. Tell them in every way that you can, be that a newsletter, a website, or a mailing. Do an email mass blast. Make sure that your community members know what the rules are. They can't follow a rule if they don't know what the rule is. So communicate that with them. Be clear with them. Unit members, you got obligations as well. You need to know what the association's policies are so that you can follow them. If you don't know what they are, ask for copies of them, review them, understand them. I can't encourage that enough. board members, anyone that was on our last HOA forum, this is a verbatim from our budget meeting last time, which is do not rely on late penalties or fees or interest to fund your community. That's what assessments are for. So, you shouldn't be looking at this as a revenue generator. Penalties and fees and interest, those are to incentivize a unit owner to comply with the law, to comply with their requirements, excuse me, their obligations, not to, but not to make it so that you guys can build a new clubhouse. So, those fees should be reasonable. They should be enough to encourage compliance, but also you shouldn't be saying, oh, I hope that we can get 75% of our annual budget from late fees and penalties this year so that we can do this, that, or the other project. And finally, on a closing note, everyone on this call, I encourage you to pay attention to our website and to pay attention to the Colorado General Assembly's new legislative session, which is starting in less than 1 month. They're currently scheduled to convene on January 9th of 2023, and it's expected to last through for a few months, probably through late April or early May. And in that vein, we will no doubt see new laws that will affect HOAs in one way or another. Stay tuned to our office, and we will do our best to keep you up to date on these changes. And with that, maybe we can answer a few more questions, Amanda. We still have a lot of participants, so I'm happy to answer questions for a little bit here. Even though I know, of course, we are over, but I'm happy to keep on answering some questions if we can go through a couple more.
Okay, yeah, we do have actually quite a few in both the chat and the Q&A. I'll start off with the Q&A, of course. Let's see. Gosh, there's so many of them. You guys have amazing questions. All right, so what if a unit owner cures and then re-violates repeatedly? Is that what you're saying? For instance, if RVs are not allowed to be parked overnight and a unit owner continually violates without going beyond the 30-day limit?
It's an excellent question. I don't have an official answer for you. I think that the circumstances could be interpreted differently by one judge to the next, and therefore, but ultimately it would be the decision of a judge to rule on whether that is a continuing singular violation or not. But just on the plain language of the statute, I think that there are perfectly valid arguments in either way, but it appears to suggest that if I park somewhere illegally for 5 days and then I drive around the block or drive to the store and then come back and repark illegally, that's probably going to be construed as a new violation. If that it doesn't make much sense, let me be candid with you, but I do think that that's what a court would probably just determine. But again, I am not a judge, so I cannot make that ruling. I think that the factual situation there is very important, and all the more reason why I would encourage you board members to very carefully detail and any of these types of scenarios such as that.
Okay, great. Okay, so thank you so much for answering that one. I know we kind of went over this a little bit as far as the pre-Kiowa and if it pertains to the pre-Kiowa as well. I know you answered yes to that one, but there's also a follow-up question with that is there are single-family homes, and a neglected property can cause great damage to property values and also be a health hazard. The HOA cannot really take action on a homeowner that ignores violations if foreclosure isn't allowed.
Well, I mean, you mentioned property values and you mentioned a potential for health and safety. And I think that there could be a sound argument that a reasonable board could get together and say that rodent infestation, if we're talking about perhaps hoarding situation or something to that extent. But I will tell you that weeds that are tall are not a health and safety violation. Abandoned cars are probably not going to be either. So it's very hard for me to tell you what a health and safety violation is, and so in that situation, it's really very factually dependent, and but a court is going to rely on the reasonable judgment of a board in making a determination on whether it is a health and safety violation. I think we can all agree that flooding, an open valve flooding water, standing water in a basement of a building, because something like that, that is clear, that's unequivocally a health and safety violation. But there are some of these other areas, and that's why I would encourage your boards, you board members, to expand on that, to determine what a health and safety violation is, and also make that clear to your community members through dissemination of your policies. Make it clear to them so that they know what to expect in those scenarios.
Perfect. A few more. So does House Bill 22-1137 rules of notification apply to the ACC violations that do not have a fee attached?
I think yes, it does. You still would have the same requirements to notify them of a violation, whether or not you have a so to speak teeth to enforce that with. I mean, if your ACC says no outbuildings, no chicken coops, for instance, you still would have the notification requirements to inform them, but of that violation. So yes, I do believe so.
Perfect. We do, like I said, we have quite a few, so let me just go ahead and find some more here. Sorry about that.
I'm gonna jump in real quick on one. Does executive sessions require notes to be taken by the secretary? And if so, are those notes to be made public to all members of the HOA? The executive sessions are not open to all of the members of the HOA, and in fact, executive sessions are only open to, under that limited circumstance, to the affected unit owner under subsection E, to the extent of for them to know the result of the vote on whether or not an association is going to be passed along, or if a unit owner is going to be referred to collections.
Oh gosh, okay, we do have one in here. If a homeowner doesn't pay the January dues and they charge an 8% annual rate, and then the next month they don't pay again, can they add another annual rate interest to the January and February dues? As far as like, can they combine them together is what they're asking.
If I understand the question, if I'm on a payment plan for a past due amount, I am required to continue to pay my current assessments along the way. So is that, I think, is that an answer to that question? I'm not quite sure.
The question is if a homeowner doesn't pay the January dues of $1,000 and we charge 8% of annual rate, the next month, February, they don't pay again, can we add the 8% annual interest rate to the January and February dues, as well as the unpaid 6.66 interest from the last month? So basically, can they charge interest on unpaid? Yeah. So kind of like what your answer was, yeah. Gosh, okay. There's so many questions in here. Okay. All right. So Dawn wants to know, there were 119 HOA foreclosures that were filed in 2019. I don't know if that's a question or if that's a comment, Dawn. So it says, all he says is that it was a rush legislation to address a couple of very aggressive associations. So I
Well,
know,
and that goes to what I was talking about before, which I'm not sure if I entirely agree with about that. Some of the individuals that are I think attending presently on this webinar worked on this bill specifically, and this bill was in the works for some time. And so while yes, through the legislative session there were several amendments and changes along the way, that admittedly is true. This bill was very carefully tailored over several months leading up to it, and leading up to its ultimate passage. So so I don't know if I necessarily agree with it being rushed, but rather it just happened that we had this other aspect of life going on where the media happens to catch on to and talk about, and that certainly drummed up interest in the bill, because at the same time that the media was covering foreclosures, for instance, was also when this bill was going through its legislative process. And that's why there's this misconception that the two things are intertwined, that this bill was a direct reaction to those media stories, and that simply is not the case. The individuals that I know that have worked on this bill have been working on these issues for many years, and so and very competently, might I add, and this is very near and dear to their heart for a myriad of reasons, different reasons for everyone involved. But the overall, I don't think I would construe this as a rushed bill by any stretch of the imagination.
thank you for answering that. We do have a question as far as if and when this, the House bill, if and when it will be applied to Kiowa, as far as
This bill is effective today, as of right now. Since August 10th, this has been in effect. So, this, I mean, something that I didn't explain at the very onset, and I apologize, is that the way it is maybe a little bit more about the actual legislative process. A bill is drafted, and then it's voted on by the legislature before it goes to, in this case, the governor's office. If it becomes law, that's when it technically becomes an act. But if you were to read the actual specific language of this bill, of HB 22-1137, it says basically, we are going to amend this section of Kiowa to now read as such. So basically, this bill has been incorporated into Kiowa, as well as a few other statutes, but primarily into Kiowa. So it is a part of Kiowa now, and therefore effective as of now. So if one of you were out there, you were about to send one of your neighbors to collections tomorrow, you need to pay attention to this now, so that you can comply with that law, because it is in effect and has been in effect since August 10th as its first effective date.
Perfect. Thank you. I know we answered quite a few. I mean, we went over a lot of these questions. Do we still want to go ahead and answer some more? What do you think?
Yeah, let's do a couple more here. I think. I mean, if it's something that we kind of already feel like we've already covered pretty well, then we can kind of jump to the next. But
sure. Let's see. Gosh, sorry, I lost it. Oh goodness. I did see one in there as far as the HOA not having a management company, not having, not being a mandatory HOA. Do all these still apply if HOA is not under a management company? Does that HOA then get dissolved is what the question is.
Having a management company doesn't change the status of its existence, i.e. dissolution or termination, nor does it affect its applicability to of this law. This law applies whether you have a professional management company or you are a self-managed board. It applies to small communities and big communities. It applies to rich communities and less flush with cash communities. It applies to everyone in that respect. Now, how it is executed perhaps might be a little bit different. If you have a management company, a CAM, a community association management company, might take over certain aspects of the responsibilities, i.e. drafting the letter or delivering the letter, mailing the letter, or posting the letter in the case of an assessment delinquency. But whether or not you have a CAM or not, these same processes are required. These same notification requirements, the same interest rate reduction from what was permitted before, all of those things apply whether you have a management company or not. That's a good point. A good question to ask.
Sure. Okay, John,
Hey,
again.
David, let me jump in here.
Yeah.
Got a question here from Stacy. Seems pretty good. Does the homeowner have a right to know the specific votes of each board member or just the final tally?
Good question. It's not entirely clear. I'm going to scroll back in the slides here to the executive session slide. What it says is that they shall know, except to the extent that the unit owner who is the subject of the disciplinary hearing or a referral of delinquency may request and receive the results of any vote taken at the relevant meeting. That to me does not say David voted no, Nick voted yes, and Amanda voted yes. That what that might probably mean to me is that it was 2 against 1. So that is unclear at this point. It's entirely possible that perhaps future legislation could clarify that, or in the alternative that a judge rulings could clarify that. So unfortunately, I wished I could give you a straight yes or no clear answer about that, but unfortunately, I'm not able to.
Perfect. Okay, thank you, Nick, for asking that one. Okay, so does no fee include a status letter fees to title companies when a property is being sold, since that document is issued on behalf of the owner?
I'm not sure what you mean by no fee, but the Colorado Nonprofit Corporation Act does still expressly allow for fees for transfer of ownership, transfer of memberships, which usually fall under that same vein of what a status letter is. I certainly encourage all boards to have a reasonable fee for that. And furthermore, in some of your more complex communities where you have master associations and sub-associations, to consider working in concert with one another, with both of the associations, to ensure that you are not overcharging someone for these. These status letter issues are it's a touchy subject for a lot of homeowners. Believe me, I've bought and sold a condo too. I know what they're like, and I don't like them. But that being said, they are permissible. I encourage board members to establish a reasonable fee for it, not something where you're charging a really large amount of money for something that is essentially, for the most part, documents that a unit owner is entitled to for free because they are unit owners. When I'm saying what I'm referring to there is your governing documents, a copy of your budget, the copies of those minutes. If I'm a unit owner, I can buy, excuse me, I can request those from my association. I have the rights to go review those myself if I wish and make copies. But and I can do that for free. So for the association to charge an astronomical amount for the same service just because we're selling and transferring the property to a third to another party doesn't necessarily mean that we should be talking about hundreds and hundreds of dollars. So keep that in mind. Your community members here too, and really excessive fees like that also can affect the value of that the community has, the value of the properties in that community. Because so keep that in mind. I'm not here to say what is a reasonable fee. I don't know what a reasonable fee is because that's different for every association. But they are. But these status letter fees are permissible by based on the Colorado Nonprofit Corporation Act.
Hey, David, I don't know how much time we have left, but there were a couple folks here who were curious about the other House bills that were passed, not just 1137.
Sure. I think that probably definitely the best place to reach out to on those would be to review our legislative summaries that we have. But were there some specific questions, or was it just saying, hey, I'd love to learn more about the other ones?
Yeah, just anonymous was just asking if you can give a brief update on House Bill 1139.
Well, 1139 did pass, and it is in effect. I'm scrolling up to the list of them right now. One too far. 1139 is the limits a homeowners association or a common interest community, a CIC's ability to regulate public rights of way. If you cannot call our office and say, Nick, Amanda, David, is my street a public right of way? We don't know that information. Your community will know that information, but for you to figure that out, you can do one of two things. You could call your county or call your city if you live in a municipality and ask them about it. But also think about it from this respect: who maintains the road? Is it plowed by the city when it snows? Do you guys have to fill your own potholes? Those are some answers that help you figure out whether you have a public right of way. Is it a gated community? If it's gated, that's not a public right of way, because I'm just a member of the public and I can't go drive on that road because it's got a gate on it. Those are questions that help determine whether it's a public right of way or not. But an association that does not maintain its own roads, that does not own its own roads, is not allowed to enforce parking restrictions. Primarily, that's the brunt of what most people are concerned about here, but also other uses on that road, if it is in fact a public right of way. Maybe what we could do is look into doing a crash course forum on some of these other bills, just to give an introduction and create a situation where we could help summarize some of these other bills as well. Clearly, 1137 is we could talk about 1137 for a long time, a lot longer than we have, and maybe we can also incorporate that into a discussion of some of the other most recently passed bills too. Would be a refresh on, or maybe addressing some of the questions that we have here, but that we aren't going to be able to get to today. But so our office will look into that and see if that would maybe be something that we could do in the near future. I think that it certainly could be helpful for all of you. But 1137 in and of itself is such a complex and comprehensive bill, and based on the types and numbers of inquiries that we've received in our office, both leading up to its passage as well as after its passage, is really what dictated the fact that we wanted to call this bill to everyone's attention in particular because of its uniqueness, because of its comprehensiveness. With that being said, let's leave some of the other bills to that. And in the interim, I would strongly encourage everyone to review our legislative summaries, which can be found on our website, as well as at the following link. I'm almost there. There we go. Let's do one or two more questions here. I know we've gone long over, but they're good questions. Anything else?
Okay, we got Jackie here. Senate Bill 22059 with annual meetings coming up once again. What is the limit on collecting proxies by board members?
This bill does not change the limitations on numbers of proxies that a homeowner or a board could collect. What this bill did was clarified some very minor language to clarify and stated so that there was no confusion that now all proxies are valid for up to 11 months unless a shorter period of time has been expressly stated in the or on the proxy. So it does not change the effect or the ability for a unit owner or a board to collect proxies. It only has to do with the duration or the validity, the time frame that a proxy is valid for. Let's do one more.
Okay. Oh gosh. I know we just answered Jackie's. Oh God. Okay, I'm not sure if we answered Deborah's at all. So do proxies still count if no signature was required on the document?
They must be executed by, and they also must have a specific appointment. They can't be blank unless there is specific language in that document that says if left blank, then the proxy is being granted to a specific, usually a board member in that situation. I cannot just say I give proxy to someone, but as one of the individuals that's on the call here points out often, and I agree, is that a proxy can be written on a bar napkin. It can be written on anything. It can as long as it's clear as to its appointment, what its intentions are. So yes, in that respect. Perfect.
Thank you.
Well, what I will do, ladies and gentlemen, clearly there is lots of interest in this topic. We will go through and review these questions, and let's see how we can either consolidate some of them. I mean, a lot of them certainly might be, well, this is the situation in my community, but another person might be asking a very similar question too. So we'll go through and see what we can find about find some commonalities in these questions and see about how we can most effectively share some of those answers. But in the interim, I certainly would encourage you, if you have specific questions about your community, that you may reach out to our office. That is what, in fact, we are here for, and we are happy to help clarify what those rights and responsibilities are for you and your communities. In closing, I really do encourage you to take a look at our legislative summaries, because I do think that they answer a lot of these questions that you may have, but with that, I really do sincerely appreciate all of the wonderful questions and all of the attendance today. So thank you so very much for your time. Thank you for holding on with us as we work through so many of these questions. And we will certainly look forward to seeing you all in the new year, and we will go from there. But thank you
Hey,
so
David,
much.
can we
Oh, yeah.
remind attendees when and where they can get the slides to this presentation and the link to the webinar recording?
Yes, I will get that for you real quickly, and I will post that in the chat in 3, 2, 1. So I'll leave that open for a minute or so for anybody to copy and paste it out of the chat if you need. And but with that, thank you so very much, and I hope that you have a happy and healthy new year and a wonderful holiday season, and we will look forward to seeing you in the new year. Okay, thank you now. Bye-bye.